and welcome. The legal battle between DC and Fawcett is possibly the most well-known lawsuit in comic book history. Most of its notoriety is possibly due to DC's somewhat outrageous allegation that Captain Marvel is a direct copy of Superman. Certainly, they have slightly similar features and they do have vaguely similar powers, but they are fundamentally different characters with completely different origins. Regardless, a lawsuit did move forward in 1941, but it wouldn't be resolved until 1954. Furthermore, while DC technically won, it wasn't a victory strictly based on points of law. Historically, this is one of the longest copyright disputes in American legal history. However, this wasn't the first lawsuit DC filed claiming another character was a clone of Superman. That distinction goes to an obscure character named Wonder Man. Wonder Man's debut, and only appearance, was within Wonder Comics number 1 from May of 1939. The character's secret identity is Fred Carson, who is supplied a magical ring that gives him supernatural strength, the ability to leap great distances, and he's invulnerable to harm. Conceptually, this does sound very similar to Superman, who debuted a year previously in Action Comics number 1. Although, the magic ring is quite a noticeable difference between the two. Wonder Man was created by the legendary artist Will Eisner, who, under a pen name, also wrote and illustrated the story. He was specifically directed by the publisher, Victor Fox, to create a superhero that was a copy of Superman. And that's exactly what Eisner did. In fact, Eisner wrote a disguised version of these events in the 1986 graphic novel, The Dreamer. Obviously, DC noticed this direct ripoff, filed a lawsuit, and won the case. Now, this case is significant for a few reasons. Historically, it's the first copyright infringement case in comic book history. Secondly, it established that DC was legally prepared to tenaciously protect their best-selling, most important property. And finally, it established that a character only had to be similar to Superman in a few key areas for that character to be considered infringing on DC's copyright. Captain Marvel debuted in Whiz Comics number 2 in December of 1939. For the record, there is no Whiz Comics number 1. The first issue was an 8-page black and white mock-up sent to distributors in order to secure copyright on the Captain Marvel character. To be accurate, Captain Marvel was originally called Captain Thunder, and Whiz Comics was originally titled Flash Comics, then Thrill Comics. By all accounts, Whiz Comics and its eventual spin-offs, Captain Marvel Adventures, Captain Marvel Jr., and the Marvel Family, were undeniable hits. The circulation of Captain Marvel alone was quite impressive. It sold 500,000 copies per issue during its debut year, and by 1945, it was selling an estimated 1.3 million copies per issue. During this period, the comic was also bi-weekly, making those sales figures even more impressive. During this time, Superman was also extremely popular, and DC did everything it could to capitalize on the character's success. This included licensing the character for a variety of merchandise, a daily newspaper strip, cartoons, and a radio show. Due to these contractual obligations, and the profit being made from them, DC was in a position to vigorously defend its copyright on this character. If they didn't, Superman's uniqueness would be diluted, and his marketability would be compromised. In 1941, DC filed a cease and desist notice to prevent Fawcett from publishing any further Captain Marvel comics. However, Fawcett completely ignored this notice and, seemingly, didn't respond to it whatsoever. This forced DC to pursue legal action. It's possible, and this is pure speculation, that DC believed the threat of legal action would get Fawcett to settle out of court in order to avoid a costly trial. After all, DC had won the case against Wonder Man, and they had a legal precedent on their side. However, Fawcett wouldn't concede. The reason most likely being, Captain Marvel was extremely popular, and his comic book was, reportedly, outselling Superman. Basically, Fawcett had the capital to fund a reasonable legal defense. More to the point, Captain Marvel wasn't a copy of Superman, according to the creative talent responsible for the title, and the perceived similarities were slight at best. The list of similarities, according to DC, included invulnerability to bullets and knives, flying faster than a speeding car, lifting huge boulders and catching heavy objects, breaking steel bars, snapping handcuffs, crashing through doors, and a form-fitting costume. Or in basic terms, invulnerability, flight, super strength, and a costume. All are quite common elements to superheroes. However, the specifics were important to the case. Reducing them to generic terms also reduced the unique properties of Superman. Furthermore, by being very specific, the lawyers could pull examples from the comic books to prove their case, which is exactly what they did during the trial. The substance of Fawcett's defense was twofold. For one, Captain Marvel was not an imitation of Superman. This was an obvious, standard denial. Secondly, and more importantly, Fawcett claimed that DC didn't have a copyright on Superman. So even if it was determined that Captain Marvel was a clone of Superman, DC was owed no damages because they did not own the character. On the surface, that sounds like a ridiculous position. However, it had a sound legal argument and evidence to support it. Moreover, the trial judge agreed with this position. The simplified decision in the original trial from 1950 found that Captain Marvel was actually a copy of Superman. This is due to testimony from freelancers who claimed they were directed to copy Superman artwork and stories. It was also based on artwork similarities found within the comic books. Although, it should be noted, there was an excess of Fawcett creators who denied these allegations. However, because of the Superman newspaper strip, DC hadn't properly asserted its copyright. Therefore, Fawcett owed DC nothing in compensation. This part is going to take a moment to explain. In essence, the daily syndicated newspaper strip didn't have proper copyright notices attached to it. Therefore, those stories had no copyright protection. Furthermore, the stories in Action Comics were so similar to the newspaper strip stories that they were functionally identical. Or, in other words, Action Comics was derivative of the newspaper strip. Therefore, because DC allowed the newspaper strip to be printed without the proper copyright notice, the company had forfeited copyright and the protection it offers to Superman. The logic is bizarre, but it is sound. In the end, Fawcett had both won and lost the trial. Captain Marvel was legally determined to be a copy of Superman, but no damages were owed because no copyright existed. As one would naturally presume, DC appealed this decision. In 1952, the appellate judge determined that DC did have the copyright to the character and overturned the original decision. Due to Captain Marvel being a copy of Superman, Fawcett was now in a position to pay damages. Again, for the sake of simplicity, DC then had to prove every single instance of infringement done by Fawcett. This entailed going through Action Comics and Whiz Comics and citing specific examples where Action published a panel or story that later appeared in Whiz. Only then could damages be determined. For the next 2 years, this is exactly what DC did. In turn, Fawcett was prepared to refute whatever examples DC provided. 2 years later, in 1954, Fawcett settled the lawsuit with DC instead of proceeding to court. Fawcett paid DC $400,000 in damages, and they discontinued publishing their superhero comics. On the surface, it appears that Fawcett simply admitted defeat, which is partially true. In 1954, superhero comics were on a steep decline, losing their popularity to horror and crime comics. Furthermore, public opinion towards comic books was becoming noticeably negative. Seduction of the innocent and its baseless claims concerning the harm and influence of the medium on developing minds was on the near horizon. With public opinion and profits in decline, Fawcett put an end to this tedious legal case. In the end, DC won, but they hadn't proven any actual instances where Fawcett had copied their material. Whether DC could have legally proven their case is a matter that will never be determined in court. Despite canceling its superhero comics, Fawcett Publications didn't go out of business. In fact, it successfully existed until 1977. It was then sold for a reported $50 million, and it was subsequently dismantled and absorbed by CBS Publications. Captain Marvel disappeared from comic books for nearly 20 years. In 1972, DC acquired the license from Fawcett to begin publishing further adventures. Unfortunately for DC, the trademark to the name Captain Marvel had lapsed in 1968. During that year, Marvel Comics quickly published a new character named Captain Marvel to obtain this trademark. Marvel Comics has maintained this trademark ever since. Thus, in 1972, Captain Marvel was retitled Shazam, and DC would periodically publish his adventures for the next few decades. In 1991, DC purchased the character and his derivatives outright. Since then, Captain Marvel and his extended family have been integrated into the mainstream DC universe. Before I get to a few relevant notes, I'd like to make a brief, self-serving message. If you're new to this channel, please subscribe. This ensures you're notified of future releases. Liking the video and leaving a comment also greatly helps. Unfortunately, this channel has experienced a steep decline in visibility in recent months, and, I must admit, it's become quite concerning. So any support would be greatly appreciated. Thank you. As I mentioned at the beginning, Superman and Captain Marvel are rather different characters, and I didn't do a comparison to highlight those differences. Honestly, I think if one is only slightly familiar with both characters, the differences are self-evident. So it seemed kind of unnecessary to elaborate on this point. I do have to stress that I greatly simplified, for the sake of clarity, the details of the legal decisions. In particular, the determination that DC had inadequate copyright notices on the Superman newspaper strip. Trust me, that portion of the case is a legal rabbit hole. Regardless, the spirit of the decision is accurately represented. The one thing that did surprise me is I couldn't find any reports that Fawcett had appealed or intended to appeal the decision that Captain Marvel was a clone of Superman. This is rather surprising. It seems that this would be a logical step for the company. Or perhaps they did appeal and it was denied. I simply didn't find any information one way or the other. I can only speculate that Fawcett didn't anticipate the copyright issue to be reversed on appeal, and they weren't prepared for that result. By the time the reversal occurred, sales on superhero comics were starting to decline, so I'd have to speculate that someone did a cost analysis of an appeal versus a settlement, and in the end, settling was the cheaper option. Alright, so I think that covers all the dangling threads I thought needed to be addressed. Once again, thanks for watching. That's it for today. Like, share, subscribe, and comment, and I will talk at you later. Until next time.